Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. Today, we have another spectacular webinar, part 9 out of 10, with the fabulous Bryan Thomas on what about priority, the visible commencement standard in Tennessee. So without further ado, I introduce the fabulous Bryan Thomas.
Thank you, Ariel. Welcome everyone today. We've been going for a while and we're sort of at the back end of the Tennessee lien law and understanding some of the aspects of it. And today we are talking priority, and priority is a key as to the effectiveness of a lien, both of why it works as leverage to get paid and the problems if you do not follow the lien law correctly. So with that, I am going to jump in. Feel free to ask any questions. I'm glad to answer them during the webinar today or after. And Ariel's great follow-up if we need to do that as well. All right. So where are we? We're at the very end, 9 of our 10-part series on liens. And so we're talking about priority today. We've got one more to close it out here in December, and hopefully you'll be able to join us then. So as we start talking about priority, we've still got to talk about a summary of where we are with liens in Tennessee. Liens in Tennessee, the lien law is written in 2 parts. We really got remote contractors and prime contractors. The requirements are a little different for both. We're pretty wide open on what is considered an improvement and your ability to get to the property interest of which the person you contract or the ultimate person that is contracted with has at the time, and you're able to get a lien for the contract price. That contract price can include extras. It can't include some other things like attorney's fees. So big picture, that's the 30-second summary of Tennessee lien law. The how do you do it side in 15 seconds is prime contractors have to file a lawsuit within a year, and remote contractors have to follow the trifecta of notice of non-payment, recording the notice of lien, and then perfecting the lien with lawsuit. The second step for the prime contractor is a requirement just for priority, and we're going to talk about that some today, and that's whether or not the prime needs to record the lien within the 90 days of completion or abandonment. All right, so let's start at the beginning here on priority. And the first question is, how does priority work among lienors? In a project that goes bad, somebody goes bankrupt, and you've got 10 different folks who've liened the property for their work on the project. And the answer to that is we've now got a third category of people. We've got prime contractors and remote contractors. And now we've got individual laborers who are actually doing the work that have a lien for their unpaid services. So what Tennessee lien law does, or what Tennessee statutes do in the lien law, is they give that individual laborer a priority interest over all other lienors. Otherwise, everyone that liens prime, remote, and remote again can be a sub or a sub of a sub or a supplier of a sub. Everyone shares pro rata and equally, and there's some case law on this that essentially says it's going to be total amount claimed versus total amount available if you sell the property from a lien action. And everyone is going to share based on that proportionate value. So that's the basis upon which you share with other lienors in Tennessee. Now, one very useful tool is that liens on the property actually have priority over judgment liens. That means that there is a prior judgment against the owner of the property, the mechanics lien is actually going to have priority over it. And that is a unique exception, and there's some limitations to that because of the unique aspects of it. But in theory, it makes some sense because the lien, again, is for the improvements to the property. And so you want to make sure that anybody actually made those improvements and conferred a benefit have the priority over an old judgment liener. All right. So that takes us to third parties. How does priority work in Tennessee with third parties? And the answer is it all goes to this concept that Tennessee have of visible commencement. And the idea is that upon visible commencement, the lien attaches to the property, and therefore that is the priority date for all contractors working on the project. Okay, so that gets us to the question of what is visible commencement, and we'll get to the specific definition in the next slide. But I want you to pay attention to the yellow language here, because it's the exact same language we're going to see when we go to the definition of what is visible commencement. And really, what I want you to note is there's some time period before visible commencement on which work is being done, in which a deed of trust, Tennessee's a deed of trust state, but a deed of trust can be recorded for a bank to have priority, or another third party who takes an interest in the property that would trump a lien. And this is important when you look at the back end on, okay, where is the leverage with a lien? In a lot of projects, particularly in some periods in the past, there wouldn't be a lot of value in the property that was not encumbered by the deed of trust or mortgage from the lender. And therefore, it's great. You could go to try to foreclose on your lien, but if the property is not worth more than the lender's deed of trust that's ahead of you, your lien really wasn't worth much either, other than triggering a default under that loan and requiring the lender to step in and start protecting their own interest. So it's always a little bit of a catch-22 as to, okay, do you want to proceed to impact title and lien it and try to push that lien, or do you want to try to give the owner a little bit more leeway in terms of trying to correct and get to a position where they can pay you? So big picture, that's why this really matters when we're talking about who has priority, particularly between the lender on the project and the lienors. So the other thing I will note on here is visible commencement can be multiple time periods, and you'll see this concept in here about a subsequent visible resumption of operations. And this concept is embedded throughout the Tennessee lien law, in the sense of we've got a implied abandonment after 90 days if nothing's happening on a project. So, you know, it's not all that uncommon for a project to get started and get right on that edge of what is visible commencement or what is not visible commencement, and then get stalled through the financing efforts and, you know, maybe get put on the shelf for 180 days. Or for instance, you know, in the last year, we've seen a lot of projects that were put on the shelf for a year, year and a half, and are now beginning. So our lien law really treats that gap as almost the start of a new project if that gap is longer than 90 days. So you see that concept here embedded in the visible commencement and the visible recommencement, if that is applicable. So exactly what is visible commencement? Here's the definition you're going to see in our lien law. Again, the yellow language is the exact same yellow language you saw in our priority statute. But what is it? There's some case law out there that it's not just delivering some pipe to the property. It's not clearing the property. Some of those are in your express definition or of the exclusion down there in the yellow language. What it is a little bit of a flexible concept and one to be determined on the facts of each case as to the particular date in which something is delivered, quote, of such manifest and substantial character that somebody should have been aware construction was ongoing. Well, arguably, a lot of the things in yellow that are specifically excluded should do that. So where that leaves you typically is once you get past any express exclusion in yellow, you have triggered visible commencement. And that triggering of visible commencement gives the priority for all the lienors that are going to come subsequently. Okay, so that gives us what is visible commencement. That's the date at which our lienors are going to get the priority in the property. And I put it here in sort of a timeline form for you so you can see the typical form, which is we've got the start of a project. Now, start can mean a lot of different things. It can mean staking a property, it can mean clearing, it can mean getting plans to the city. It can mean a lot of different things to a lot of different people. And that's pretty irrelevant, quite frankly, under Tennessee lien law. What is relevant is the next one, which is visible commencement, because that's what triggers the lien priority. And the question you'll see up there, I've got a deed of trust in this case, in this timeline, before visible commencement. And that's your typical project structure in which a lender is going to have priority over the lienors. That said, there's plenty of projects where I've seen this done less than ideally, in the sense of it's not clear whether visible commencement is before or after the deed of trust. In those situations, a lienor has extensive leverage to get paid. So that's one thing that you need to be aware of as you're thinking, okay, how valuable is my lien and when is visible commencement versus when I go look at the property records when the deed of trust was filed. All right, so as with everything good in the law, there's always an exception. There is an exception for the lienors to get back to a priority position over a lender. That requires some notice, and very particular notice to people, and either a response of acceptance or a lack of response from the lender. I will say in my practice, I have rarely seen anyone try to exercise or try to utilize the statute to gain priority on a lender prior to commencing construction or working. The cases that I have seen are prime contractors who have been in consultation with the owner in their financing efforts and made it a condition of the financing. It is extremely rare to see this, but it is an option under our lien law. The red language you'll see there on the screen kind of gets you back to what our baseline rule is and what you typically see, in the sense that the lender is going to have priority because they are going to file a deed of trust before visible commencement. In fact, it's going to be one of their conditions and express requirements to an owner under the lending documents. All right, so that's the lender exception. The other thing we got to think about when we're talking priority is, okay, who's got priority and who's got the ability to get to materials that have been delivered but not paid for? And the answer to that is, if materials have been delivered but not paid for, then those materials aren't subject to the lien. And the reason is you don't want other lienors being able to get to material that has been delivered but not yet paid for. And now that also goes to what we're going to look at next, which is a lienor's ability to actually go repossess materials prior to their incorporation into the project. And so this is a unique exception that allows a vendor to go repossess their materials rather than continue with a lien. So they're protected on both sides. They're protected and they expressly have the right to do it, and that other lienors aren't getting an interest in their unincorporated materials. So always an option if you are a material supplier who has not been paid, but materials are sitting on the property but not incorporated. Sometimes best bet is going to pick them up. All righty. There are other sections here as to exactly what can be done in those circumstances, and I'm going to leave those details for a different discussion, but the statute is on the screen for your reference. Why do we talk about all this? I'm circling back to where we started maybe week 2 as we started going through the 10-part or 12-part lien series. And it's the question of a prime contractor. And remote contractors are required to record the notice of lien with the recorder of deeds, so it's in the chain of title for anyone looking at it. And that's the 90-day requirement after the notice of non-payment for remote contractors. You remember, prime contractors arguably don't have to file anything in the chain of title other than commencing the lawsuit to perfect the lien within 1 year. The problem or the risk for the prime contractor is they will lose priority to a subsequent purchaser. And this is the statute that we have on it. And I would tell you, there's one part when you're looking at remote contractors, we've discussed it before, but the key for remote contractors is if you filed a notice of non-payment and the owner plans to sell the property, the owner has to provide notice to the remote contractor. Same for the prime. And I've got a number of prime clients that have argued with me, well, if the owner's got a duty to notify me as the prime contractor, if they're going to sell the property, why do I need to worry about recording the notice of lien within 90 days? And my answer always is you never know exactly what the facts are going to show, or when a notice went out that you just simply didn't get, even though it was properly sent. So again, all that, let's talk big picture priority. Your lien is as good as the interest to which it attaches and the priority over whom you have. And if you are a remote contractor, you don't have a lot of leeway here. You got to comply and record anyway. So your priority is kind of the same as the requirements for establishing the lien. If you are a prime, on the other hand, going ahead and taking the second step of recording the notice in the chain of title within 90 days of completion of or abandonment is recommended, so we're not having a priority fight with a subsequent purchaser. And that is what's on the screen in section 112 of our lien law. All right. So with that, that is priority in a nutshell as to how lien priority works in Tennessee. Key again is going to be visible commencement, with a couple of exceptions that we talked about today. The reason for all that is typically going to deal with a with a lender and their deed of trust, and whether or not it was before or after visible commencement. And on the back end, we've got the question of priority with respect to a subsequent purchaser. And the recommendation is for a prime to go ahead and file that notice of lien in the chain of title with the recorder of deeds to make sure we don't have an issue there. That's priority. If there are any questions, I'm glad to answer them. Otherwise, we will be back again in about a month to wrap up our series. Ariella, any thoughts or comments?
Wonderfully done, as always, and we do not have any questions at the moment, but if you have a question in the future, below is the contact details of Bryan, and of course you could reach out to me at any time. Thank you so much, Bryan. I wish everyone a sunny and great day.
Thank you, and thank everyone out there.